We're going to move directly, and we're falling behind schedule, so we're going to move directly into our next item. Approve rule changes proposed by the Civil Litigation Rules Revision Task Force. We have former Governor Dan Bridges here, who is chair of that task force. That task force has been renewed several times, and even if the board approves these rules today, I think there could even be further work to do. So keep that in mind. And former Governor Bridges, Chairman Bridges, welcome back to the board table, and you have the floor, sir.
Former governor, former treasurer. My goodness, I'm getting demoted. Very nice to be with all of you folks again, and I'm sad that we're not in person. Let me kind of get my notes back. Okay, I can do this fast or I can do this slow. I propose to do it sort of medium. Since we have a lot of new faces around the board table, I think it would probably be helpful, and although this will be redundant for 2/3 of you, to give a quick primer of how we got here. I think I can do that pretty fast. A long while ago, a board, not this board, but a board created what was called the ECCL task force. ECCL stands for Escalating Costs of Civil Litigation. And they asked that task force to study civil litigation and determine if we could come up with new rules or procedures to decrease the cost of civil litigation. That work group did their work and then came back to the board with a long list of proposals. Having already been elected at that time, but not yet on the board, I was at the meetings and I had the ability to sit in on all of the meetings where the ECCL discussed what their proposals were and the board voted on it. The board, I think, spent a lot of time on those proposals, and what they did was they went through each one and sort of ordered a la carte. I think there were 11 or 12 proposals, if memory serves, and they up or down approved some and disapproved others. And those were stated as policy values. For example, early mediation. Sorry? Okay. If my microphone goes down or I start cutting out, please interrupt me. Anyway, so like early mediation is an example. The board did not necessarily say what we want for mediation, but for example, let's explore the idea of early mediation. And then, as the board is wont to do, they created another task force to go out and draft rules to implement those policy goals. That task force spent a while drafting proposed changes to the civil rules to adopt those policy values. I was the liaison, the board liaison to that task force for quite a long time. And though I would never claim to have been at every single meeting, I was at almost every meeting when I was the liaison. So the work group felt its hands were tied in terms of what it did. It felt it had a charter, which was to adopt certain rules within these policy values, and those were their marching orders, and that's what they were going to do. And, you know, frankly, they're probably right. That is how work groups work. And the reason why that matters is that in the course of that work group doing its work, various stakeholders, once they started looking at these rules, started to complain about them. Either in terms of how they are being drafted, or more specifically that the rule itself in practice really wasn't going to work. The work group decided, it'd certainly be respectful and listen to that input, but that it was powerless really to take input that a given rule wouldn't work because the board told the work group to create a rule. So they went ahead and created those rules. Being the liaison, they did a lot of work. I'm not trying to minimize that. And because they did a lot of work, they ran out of time. What I mean by that is their original charter required them to come back with final proposed rules. I think it was 4 or 5 months before they were actually due. And for the new governor, so you understand, the Supreme Court, of course, adopts the rules, and they have, I believe it's on their calendar once a year, could be twice, but once a year. It comes up on a cycle. And the original board had targeted the due date of the original civil rules work group to be done by a certain date. So the board could have those rules and take comment from the public and the members and then decide what they would do with them. Because keep in mind, board, and I'm preaching to some of the choir, your role as the board, and I'm going to be very specific to the civil rules, is to decide whether the civil rules work group, my work group or the prior work group, did what you asked us to do. Right? You're the ones who have the decision, not the work group. It's also the role of the board to decide, having asked the work group to create rules to further certain values, to decide whether It works. Maybe in practice, although it's a great value, it doesn't work in a rule. Or maybe having a rule, the board realizes, that's a great idea, but it creates all these unintended consequences. So simply setting forth on a path to draft rules is not the end of the process once rules are returned. You guys have to look at them and decide, did the work group do what we asked them to do? Did they draft the rule as we asked? And if they did that, do we agree it's still a good idea, or are there unintended consequences that we now feel that outweigh adopting the rule? So to bring this full circle, and the last bit of my history lesson is the prior Civil War Rules Work Group asked for 2 continuances of their deadline. And being their liaison, I made the motions for them because better to have something slow and right than fast and wrong. The problem is with those continuances, by the time they were done, and by the time those were ready to be voted on, we were at the end of our fiscal calendar. We were right up against the due date for the Supreme Court to take draft civil rules. And we had no ability at all to take any stakeholder input as the Board of Governors to decide those things you need to decide. Being that the task force do what we asked them to do, and having done that is a good idea. And in fact, at that final meeting, we had it twice. The first meeting where it was presented, there was no opportunity for the board to even ask a question. It was just a straight, here's the rules. At the second meeting, we had 5 minutes. We had no time, and certainly no time to take stakeholder input. So there was a lot of stakeholder input. It wasn't all bad. There were a lot of great changes in those original draft civil rules, but there were some problems. And the litigation stakeholders, I'm going to look down at my notes here, King County Litigation Judicial Committee, the WSBA litigation section, WDTL, Washington Trial Lawyers, WSAJ, formerly WISLA, and DRAW, who are our core litigation constituents, had some very meaningful input to provide on it. And at that point, we had no ability to take account of it. Interestingly, that was a period of time when we were honored to have Chief Mary Fairhurst attend some of our meetings. And so while we were wringing our hands about what to do with deadlines, as Chief Fairhurst often did, cut through the BS and said, guys, don't worry about the deadline. Get it right. And when you get it right, give it to us. And so the board said, great, we'll do that. And so what we did was at the time was we tabled them and created a new task force specifically to take that stakeholder input, the stakeholder input that should have been taken before it came up for a final vote. I was flattered and honored to be named the chairperson of that, which is why I'm talking to you now. I made every effort to get in contact with every single stakeholder, and I did. I wrote letters to them, and I'm pleased to say that we had essentially 100% attendance at our meetings among the stakeholders. At every one of our meetings, we had a representative of all of those entities I said to you before. And I also made contact with the prior Civil Rules Work Group to be sure that they knew that they were invited and we weren't trying to shut them out. But our intention in creating this most recent task force was to be sort of a lean, mean fighting machine, have a smaller group, and let's be narrow in our focus. So that's what we did. So that's how we got here today. COVID did slow us down. We were on the course of having personal in-face meetings, and then that got thrown off the rails, and frankly, threw all meetings off the rails. And I will concede I failed you in a little bit, where in all that chaos, we didn't have meetings for a little bit. Then we got back on track, and we had a lot of really great, we had a good handful of virtual meetings where all of those stakeholders were present. So that's the history of it. President Majumdar, may I pause for a second, and before I get into the substance of it, which won't take too long either, ask if, particularly of the new governors, if there's any questions so far, and then I'll go into the next issue. Is that okay?
Yep.
Maybe there's no questions, but
Procedural questions? I see Governor Abel putting a phone symbol at his, but maybe he's saying call me. I don't know what he's saying.
That's the rock on symbol.
While governors are or hanging loose, perhaps. I see Governor Williams-Ruth has a question, but before I get to that, I'm going to do a short commercial from the Brain Center of the WSBA. I just want to remind everyone to remain muted when not speaking, and for those on the phone to press *9 to raise your hand and *6 to unmute. Thanks so much. Governor Williams-Ruth.
Thank you, Mr. President. Thank you, former Governor Bridges, for your submission. It was very helpful as a new governor for me to read that. The only question I had, and you may have heard me say this before, is was any part of consulting with academia part of the stakeholder group that you reached in? Just because I'm realizing that back 20 years ago, we were educated purely on the federal rules of civil procedure, and they were pretty much identical to what our state rules were. And so as I was seeing all the redlining, I just was curious about what is this going to do to a new law student who maybe was trained in the FRCPs and is going to come out with no clue as to what the Washington civil rules would be. Thank you.
Sure. I have three quick responses to that. I don't know that any amount of consulting with academia is going to change the dilemma you talk about, because exactly that. We're taught the civil rules. The short answer to your question, or the federal civil rules, the short answer to your question is no. We did not contact a civil procedure professor at any of the law schools to discuss this. We view these as Washington civil rules, and as we have done in the past, looked at them ourselves. I can tell you, though, and really what I suggest to you really should be the most material question is, nothing in terms of what we're giving you now is a material change from the federal rules. In fact, one of the proposed amendments that the prior civil rules work group came up with was really different than the federal rules. Not a single state had that suggestion, and that would have been a divergence from what students are taught in law school. If anything, I would submit that these rules bring us more in conformance with the federal rules. Not that I'm saying that is the gold standard or we have an obligation to follow them, but if that, to address your concern, I don't view this as a sea change in terms of how students are taught the civil rules. Although I don't know if Dean Clark is still listening. We should have a week on Washington civil rules in school. So if that's the only question, and also I talk fast and I'm very sensitive to agendas and time. So if I'm talking too fast, someone please let me know. I'm just trying to be respectful of your time. And admittedly, we've been talking about this for several years, so it starts to becoming a blur. But so that said, there were 3 big issues that our stakeholders raised. And I'm going to address them globally. The thing about a civil rule is it's like throwing a pebble in a pond. If you change one little bitty comma over here in this one rule, it may affect 3 others, simply because of not just pagination, but how they're called, is it now sub A or sub B, and all sorts of things. So we can get down to the minutia of every single rule. I don't think that would lend to your understanding of the changes. It's better to talk about what the changes are. So the first big issue that the stakeholders had concern over was the cooperation requirement. The ECCL recommended having a cooperation requirement in the civil rules. Sounds nice. We should all cooperate. The concern of the stakeholders was the rule as drafted did not have a definition. It would be left up to the subjective determination of any one judge as to what is cooperation. Further, the proposed rule as drafted would make a failure to cooperate sanctionable, no different than CR 11. So you could be following the rules, but if a judge in good faith thought you weren't cooperating in following the rules, you could still be sanctioned. So the stakeholders really unanimously had a problem with that, being litigation stakeholders. Their concern was that not having a definition would actually lead to more costs in litigation, because now we're going to be debating what the subjective definition of cooperation is. It creates peril. It quashes the idea of zealous advocacy, because if you're zealously advocating within the rules, and now you could be sanctioned for merely following the rules, although zealously, because someone thought you should have cooperated more, that would put a quelch on zealous representation. I will tell you, as a governor, I was against the proposal. But as the chair of this group, I viewed my role as being slightly different, it was kind of my job to, I don't want to say advocate for a rule, but to be sure we weren't missing anything. So I argued with the work group and stakeholders a lot over, can we salvage a cooperation provision in the civil rules? You don't like it being sanctionable. Okay, let's put it in GR1, where it talks about how nice we're supposed to be to each other. We can put it there. We can do all these other things. I suggested, it could be a lesser included offense. If you're concerned about being sanctioned merely for not cooperating, let's write it to where you first have to be found to have violated CR 11, and then a judge could consider a lack of cooperation. I tried for meetings, and some of my fellow task force members got kind of annoyed at me at a point. The reason why I'm telling you this is that I feel we did everything we could to shoehorn a cooperation requirement into the civil rules. But the overwhelming response from the stakeholders, and this isn't governors, it isn't Carla or Brian or Gene or me, it's the stakeholders, the litigation members saying, this isn't workable. We have rules already to enforce this. That's enough. And so in our draft, it came out. I couldn't figure out a way to make it work. So it came out. So that's cooperation. And I'm going to keep going, but President Majumdar, I would invite, if there's a question about a specific topic, it might make sense to do it as we go, but I'm going to keep going until you tell me to shut up. The second issue is mediation. Now, the board adopted that as a value, and the committee certainly drafted a rule. Now, here's something where I'm going to quibble a little bit with the prior committee. The board recommended that early mediation take place, but not before party depositions took place and a few other things took place, because the board, and there were some litigators on that board, said, hey, we need to have certain information before we can meaningfully mediate. Despite that being the board's direction, the prior civil rules task force, I feel actually that's a situation where they didn't follow what the board told them to do. They drafted a line in the sand: you shall mediate 6 months before trial, period. As any of you may know, in complex litigation, you may not take that party deposition until much later because of all the other things you've got to figure out first. Also, the problem we had in terms of the stakeholders was you could get out of that requirement, but to do so, you had to file a motion. And the stakeholders were saying, well, gosh, if the purpose of reducing the cost of litigation is the purpose of these rules, why are we drafting a rule that's going to create a motion in every single case? Or most every single case. So we got rid of that because I couldn't figure out a way to shoehorn that in. But keep in mind, the local rules for King County, Pierce County, I can't remember if Spokane has local rules now. Every county that has local rules already has a mediation requirement. So there's by no means a jettison of ADR. It's simply getting rid of this 6 months line in the sand. I've got a lot to say on that, but I'm not going to. My goal here is just to tell you what we've done. And then if you want to ask questions about why, then I'll be happy to respond to your questions. I will say, though, and it's in the materials, all the litigation stakeholders were really adamant that this isn't going to reduce the cost of litigation. And in fact, it's going to increase the cost of litigation. I can tell you from personal experience, I've had a lot of cases that if we mediated earlier, it would have failed and we wouldn't have had a second mediation. But mediation's right before trial sometimes gets cases settled. Okay, so the next big topic. The board asked the prior civil rules work group to draft what was essentially a federal rule mandating mandatory disclosures. What I was most taken by in terms of stakeholder input was that the King County Litigation and Judicial Committee said that was a bad idea. And always being respectful of our federal bench, which is wise and all-knowing, at least Washington litigators feel it's doesn't decrease the cost of civil litigation and doesn't achieve what its goals are. So I try to come up with some ideas, and I would love to see this work group as a jumping off point for other work. I think that some very case-specific mandatory disclosures could be great. For example, maybe we could have some mandatory disclosures for motor vehicle accidents. Produce a policy right away. Plaintiff, identify your medical providers. There are a lot of things that could be done if it's taken as a case-specific issue. Is that be faster? What does that mean? Okay, all right. I'm getting the hook from the president in a little window right there. But a one-size-fits-all just doesn't work. And really, guys, looking at my other notes here. Oh, okay. So those are the things we changed. The things that we didn't change is CR 16 pretrial procedure. Previously, the civil rule made a pretrial report voluntary. The prior board and prior task group made that mandatory. There was never a stakeholder pushback on that, so that wasn't touched. One last thing here, I did forget it, and it's a big one, is cooperation in terms of discovery. That's where the pebble in the pond affects all sorts of things because they put cooperation requirements throughout all the rules. We had to take that out because we couldn't figure out what the definition would work for that. But we did add some other things in the civil rules, one of which was an excellent suggestion by Robert Wayne, who was there on behalf of the King County Litigation and Judicial Committee. I hope he's logged on, to make the duty to supplement mandatory as opposed to discretionary. If you have a mandatory duty to supplement, it just happens instead of all this arguing back and forth about, are you going to supplement? Do I have to send you new ROGs and things of that nature? We also added a line about how people supplement. One of the problems we heard from stakeholders was sometimes a person will throw a one-line supplement into 10 pages of questions and answers. So you've got to go figure out where the supplement was, sort of hiding the ball. So we added a line there that said, if you supplement, you have to supplement with what you supplemented. Don't make it a find a needle in the haystack exercise. So that's it. I mean, there was a lot of hand-wringing over this when it came down. We haven't really changed a lot. I think I can say without reservation that we addressed all of the concerns of the stakeholders. The only dissenting voice was on one narrow thing from WSAJ about privilege logs, and that was it. But I think I can say that we had unanimous agreement on these changes in terms of going forward. There are a few other little things. I'm not trying to give them short shrift. Draw had a reasonable objection about things that are accepted from case schedules. So we fixed that, and none of the stakeholders had an issue with that. So folks, that's the long story short of that. As a 25 plus year litigator, I would be happy to practice under these rules. I think these will save us some time and reduce some costs.
Former Governor Bridges, thank you so much for all the work you've put in this. We'll take questions now. I have past President Pickett.
Hey, Dan. Good morning.
Hey, Bill.
Thanks for your just ongoing efforts. You did not give up on this. You hung in there to try to make something out of what almost it felt like a bit of an epic fail after years and years of I don't know, God knows how many hours of time put in to try to come up with something that decreased the escalating costs of civil litigation. And I've experienced, and I suspect you probably have too, that as we've worked on this for umpteen years, the only direction that litigation costs have gone is increased. Any idea what the proposals will do, hard money dollars wise, to decrease litigation? Ultimately, that was the goal. We all thought we'd get together and do something super. Any ideas or thoughts on that?
Sure. 2 points. The cost of litigation has gone up. I don't know that it's all rule-based. Experts have realized that we need them and they're charging exorbitant amounts. I mean, the cost of doing business is going up, no doubt. But whether it's a rule-based issue or something else is unclear. But Bill, I think I can say this, is that some of the changes we made will definitely decrease litigation costs. For example, whether you're a defense lawyer or a plaintiff's lawyer, you always have to follow up. You supplement your interrogatories. Do I need to, are these current? And there's no obligation under the civil rules, as you know, to supplement unless leaving the answer would be almost a deception. It's a little more nuanced than that, but that's the broad stroke. Now you just have to do it. So that prevents you, Bill, from having to pick up the phone or write a letter or get into an argument. They just have a duty to supplement, and you can rely on that. And if they don't, you have your remedies. I think that requiring a pretrial report as opposed to it being discretionary will reduce cost. I do those in all my cases, and I think it really streamlines things when we go into court for trial. Saves maybe a half a day sometimes, which is great. So I think making that mandatory will save a lot of costs. I think that taking away that mandatory mediation requirement in 6 months will definitely reduce costs, because I think in probably at least 75% of the cases, people would have been filing a motion to have taken themselves out of that requirement. So there's a motion saved. I mean, a lot of this stuff is admittedly incremental in terms of any one case, but you start adding the hundreds and thousands of cases, I think it will result in both a time and a cost savings. I couldn't say how many dollars, but I think it will.
We got any kind of mechanism in place to try to measure it, to see how successful we are? Is there any way to do that? Well,
it would only be after the fact. I mean, it would have to be, right. Did it work or not? And I'd be pleased to be a part of, getting back with stakeholders and seeing if it worked. And I would love this group simply to not be the end, but the beginning of, or the end of as Chris Meserve used to like to say, it's not the end, it's simply the end of the beginning. There are a lot of other things we could do to tweak these rules to realize efficiencies, and I'm hopeful the board would be open to looking at those going forward.
Super. And the other question I had is, did you, and I share this as a concern and a question as well. Seems like sort of the greatest stakeholder in all of this was absent from the table, and that being the public. People who are ultimately the people who pay the bills for this, right? And sort of as I was listening to you, I was thinking, okay, the goal is to decrease the escalating costs of civil litigation. And so the first thing we do as lawyers is we get the litigators all in the room who are, and I know you and I share this same burden of filtering things through the eyes of people who do that kind of work. And sort of one of the inherent biases that happens there, I think, is that we are always looking for the advantageous position as litigators. How do you, as thinking about going forward, two things. How do we keep those litigators, stakeholders somewhat involved, but also protect against that bias and involve the public or the folks who, sometimes it's insurers that pay the freight on this? Because I have a weird feeling that if they were involved, the people paying the freight, these rules would have got changed probably a whole lot differently than the way we as lawyers in our very slow moving, advantageous seeking positions change them. So your thoughts on that, Dan?
Sure. Yeah. Rajiv, if you would indulge me for 60 seconds. I agree with you, Bill. I as you might say now, having come from the dark side to the side of light representing plaintiffs, whereas I represented insurance companies in the business for about 25 years, I hear what you're saying, and I don't disagree with you on a global scale. But I guess I have three quick responses to you. We didn't involve the public. We didn't. It's a short answer to it. But, and I'm not trying to minimize the need for the public's input on some things, but to me, whether you're going to have a mandatory pretrial report or whether you're going to adopt some of these things and ask the public input on that is sort of like, and I'm not trying to minimize the role of the public, but it's sort of like involving the public in a medical setting to ask them, well, what scalpel do you think we should use? I'm not saying the public doesn't have a very important role in what we do, but in terms of these issues, I think it is uniquely the role of lawyers like a doctor to figure out what is best for the patient. Now, but where the rubber really meets the road, Bill, and I would suggest to you this, it's important to get outside the pool, not just, the litigators. But keep in mind, litigators have a huge vested interest. Bill, I'm not going to ask you to say a number, but how many hundreds of thousands of dollars do you have out of pocket right now on your plaintiff's cases that you're advancing costs on? It hurts me every day. So in terms of having a vested interest to decrease the cost, I am hugely vested and for the benefit of my clients, because I'm the one writing the checks. Secondly, on the defense side, I know the plaintiff's bar doesn't always accept this, but I'm telling you, defense lawyers, they make money by getting the next case, not milking the current one they've got on their desk. And you do that by doing it efficiently. So I guess what I'm trying to say to you is I would love to have the public at the table, but these issues are so esoteric and specialized, I'm not sure it'd be helpful. But I do feel confident that the people who are at the table have such interest aligned with the public that I think we're looking out for the public. I hope that answers your question.
Okay.
No, I think it's a good try, and I appreciate it. And the last thing I'll say, Dan, is I appreciate you digging in and staying the course on this very much. Thank you.
That means a lot coming from you, Bill. I appreciate that.
Is Betsy Lou Meow-Gix available? She indicated by email she wanted to address the board.
Yes, I am here.
Betsy Lou, you have the floor.
Thank you very much.
Just
Honorable Governors, Mr. President, did you have the opportunity to read the supplemental letter that was forwarded by WSHA? And my apologies, we did not get that to you all until today.
Unfortunately, there's not time to make it a public material, so I think you'll have to give your comments orally.
Okay, thank you. So The Washington WSHA remains committed to participating in a unified effort to analyze and where appropriate improve the rules and procedures. And we appreciate all the work that's been done by this work group in fulfilling its limited charter to revisit certain select provisions of what was done by the earlier task force. But one of the things that we believe is not being taken into account is that since the work group began their work, the world has shifted and the emphasis has gone from refining parts of the civil rules for admittedly a good purpose to just trying to figure out how we can continue to have civil litigation at all. This COVID pandemic has shifted us, and we believe firmly that we need to shift our focus from the minutia or the smaller parts of this large system to the entire system itself. There are several county groups, there are judges, there are courts. Everyone is trying to figure out how to get civil litigation moving again. There are some counties that aren't even going to resume jury trials until next year. Most importantly, the Supreme Court, with Chief Justice Stevens, has a Board for Judicial Administrative Court Recovery Task Force, which is looking at the entire picture, and that is where we believe the effort needs to be. At this point, we are not commenting substantively on the recommendations themselves, but what we are saying is that whatever changes are going to be made need to be made in a systemic way that takes into account all of what is going on now in trying to refine procedures and processes in our court system, some of which may end up being permanent or long-lived with all the electronic users and devices that are now being considered so that we can continue to have jury trials. And in the context of this procedural necessity on a large ongoing effort, we strongly feel that this should be tabled at this point because a piecemeal approach to dealing with our current situation and moving forward would not be helpful. What needs to be happening is cooperation and work through the systemic efforts that are ongoing in several different focuses right now, but primarily through the Supreme Court. It's a time when we need to be looking at the entire process. We need to see the whole forest, not lose ourselves in the weeds or the trees of smaller portions of that process. So WSAJ respectfully requests that this matter not be moved forward to the Supreme Court at this time, but be tabled in deference to the ongoing systemic processes that are in place right now. Thank you.
Thanks. Dan, I'll let you respond to that, and I just want to let people know what's happening here. Then we're going to go to Gene Cotton, then we're going to go to Governor Tollefson, and then we're going to go to Governor Grabicki. And you're on mute.
Sorry. If I understood the comments, I really don't disagree with about 95% of what was just said. But I have three quick thoughts. Doing these rules should not be mutually exclusive with addressing COVID issues, because even if we wanted to stop and address COVID issues, the issues in these rules would need to be addressed even with COVID issues. We're talking about pretrial schedules. We're talking about the rules of discovery and that. So that's always going to exist. So I would urge the board to recommend these and pass these on to the Supreme Court. But again, as Chris Meserve says, don't look at this as the end. It's the end of the beginning. We should be addressing exactly the things the speaker said. And I would invite and hope this board would not discontinue this work group, but let us keep working. Give us an extended charter so we can address exactly the issues that the speaker just addressed. There are other things we can do to decrease the cost of litigation. So let's not lose our progress here, is my point. Let's do this and then also do that as well. Thanks, Rajiv.
Thanks. My friend, Gene Cotton.
Hi, thank you, President Majumdar. and Chair Bridges, who runs a really great group. And it was a lively dialogue, and I wanted to comment directly as a result of past President Pickett's question, because Dan didn't really put this out there. We had a lot of discussion from the perspective of, these aren't just rules for lawyers. These are rules for pro se litigants, which is, my area and family law, a big deal. So we wanted to make them understandable, readable, easy to follow, even though, we all know that a huge percentage of pro se litigants don't even read the rules. But we wanted to make them accessible. And so that was very, very much considered and taken to heart. The other point and final point is, I think the other thing we all agreed on is, these are a living document, and this committee or some form of it maybe should be a permanent thing, because this should not go away. This should be an ongoing effort to deal with changing times, as the prior speaker mentioned. And it's not static, and we shouldn't let it sit there for 10 years. This thing has already been being looked at now for, what is it, Dan? 9? Close to it. It's time. We've got to start making the changes, because we're going to lose the history and the stepping stones. So, I really encourage the governors to support this. And again, thank you, Dan.
Governor Tollefson, Governor Grabicki, and then Liaison Jim McPherson.
I just wanted to thank former Treasurer Governor Bridges for his untiring devotion to this committee. Just extraordinary, tremendous leadership throughout this process. He just kept us going and going and going, and I agree with pretty much everything that everybody said so far. This is not the end of the road. It's probably the beginning. I would be thrilled to continue working on this task force for the next 3 years. I think it's a good idea. And with that said, I would like to move to approve these recommended changes and ask that they be sent on to the Supreme Court Rules Committee.
Second.
I heard a motion from Governor Tollefson. I heard a second from so many voices, but I need to identify one.
I seconded.
Thank you, Governor Grabicki, who also had his hand up, and I assume that was the nature of your hand raising? No? Okay, great. Well, is there any discussion on this matter? And I see your hand raised, so would you like to comment?
I would. I serve on the Supreme Court's Civil Litigation Task Force, and we are looking at what has to be done to bring the court system into the 21st century. Right now, it is somewhere in the early 20th century in terms of court records, filing service, all of that. With that said, I don't find anything in the work that Dan has brought before us that is inconsistent or a hindrance to what the court's task force is doing. For that reason, I seconded Brian's motion, and I urge that we move these proposed rules onto the Supreme Court in a timely manner.
Further discussion? Mr. McPherson, did you have a comment to add?
Yes, I do. I feel at least compelled and obligated to, and sorry that you don't physically see me. Can everybody hear me, though?
Yes.
All right. I am not aware that the committee undertook the concept of tabling this matter, and in fact, my board has its meeting this upcoming Tuesday, so I haven't had a chance to ask them, but Mike and Rachel have both been attending most of these meetings, at least one of them at every meeting. And it's my understanding, and I believe Dan when he says that these particular things have been hashed out and in fact have been agreed to. I will, I guess, also chime in personally, and as a past president of the WDTL and having my finger on the pulse, that I think that their position would be what we've been hearing from the last several speakers, which is let's at least recognize the effort that's gone to date and submit these. And then, if something does change and there's a brand new way of practicing law, then the Supreme Court certainly will be amenable to hearing changes. And in fact, will probably be the first to tell us that we need to be involved and to begin those changes. But at the moment, I'd like to keep the momentum going. I have sat through these meetings, as Gene Cotton has, for at least these past 10 years for Gene, or more than that, and to see this particular committee and me for 19 years on the BOG. And I'd like to see the momentum continue, and personally feel that the BOG should vote on this to see if they agree with the work that's been done by Dan's task force, and with those highly qualified, merely a handful of properly designated individuals and entities to provide input. And my little aside will be, I personally am pleased that the public was not in those meetings, because they do not have the knowledge that a litigator would have sitting through those meetings. And that's my personal opinion, nobody else's. So thank you for giving me an opportunity to speak on this particular issue, close to being past President Rajiv Majumdar.
Thank you, Gene. President, I'm just going to recognize board members from here out. We're in a technical motion. Past President Pickett.
Oh, thanks, Reggie. Hey, just quick follow-up on the motion. I support. Oh, sorry. Am I still there? Oh, there we go. Okay. I support the motion, but with this one proviso, I think it's important that we communicate to the Supreme Court that this is the beginning, and that we are, and also what Betsy talked about, this dynamic of this COVID pandemic that we're living in has to be factored in somehow, that the court knows that we've taken that into consideration as well, and know that additional changes will probably be necessary to hopefully at some point, because I don't think these changes are going to, I don't think they're going to change significantly the way the cost of litigation is happening. I don't. I hope that Dan is correct that in the cumulative there's some impact, but I don't think overall they're going to be significant enough. So I think we need more than just a tweak. And I hope that if we send this up, recommend it, that we let the court know that as well, in addition to what Betsy said about the COVID dynamic. Because what I don't want to see, though, is that to follow up on Dan's comments about doctors, if we were operating as doctors, our patients would all have been dead a long time ago, 10 years, for us to even do these tweaks. That's just unacceptable. We can't operate that, because we really are in a crisis here. People can't afford us. They can't.
Mr. President, point of order. May I ask that these remarks be directed to the motion at hand and not pontificate about unrelated things?
I would hope that we would take action.
Mr. President, may I have my point of order ruled on?
Thank you.
Hold on, Governor Higginson.
Thank you very much. I appreciate it. For giving me the time to say that. I appreciate it.
Thank you, past President Pickett. I think your point got across. Is there any more other governor discussion? Seeing none, I'm going to move to a roll call vote. Governor Abel. Governor Angelville.
Aye.
Governor Clark.
Aye.
Governor Grabicki.
Aye.
Governor Higginson.
Aye.
Governor Kang. Governor Knight.
Aye.
Governor McBride.
Aye.
Governor Peterson.
Yes.
Governor Schicchetti.
Aye.
Governor Stevens.
Aye.
Governor Swagel.
Aye.
Governor Tollefson.
Aye.
Governor Williams-Ruth.
Aye.
12 in favor, none against. The motion carries. Unless there's another motion on this topic, I'm going to wrap up I'm going to give us a short break. We're going to reconvene at 11:10, but I'm going to keep talking here. No business is going to happen until 11:10, but I have some important things to say. The rest of you can flee, and they're just personal things. This board already recognized former Governor Bridges earlier this year for his contributions to the bar, and I noticed you mentioned he's a fast talker. Well, I happen to be a fast talker too. And when I first came on the board and we did our election interviews, we did them in the same place in the WSBA headquarters. They saw me and they saw Dan Bridges and they saw our interviews and they said, people who knew me said, hey, that's the guy you're going to hate. You two are never going to get along. You're going to be like oil and water. And people might look at past President Pickett and I and think, well, they're not the closest of guys. They'll tell you what, that first year, the three of us were like the three musketeers. There was just an inseparable bond. It was a heck of a fun time and a great time. I've learned so much from both gentlemen, but I want to say about Dan in particular, when you're on the board of governors, it's like, you can be, and with your lawyers, herding cats, but trying to chair a litigation task force, that's probably more like herding tigers, literally. Litigators are the lawyers people call in when dispute resolution has broken down a lot of the time. There is no other way except to fight to get a solution done. And when I say fight, I don't mean, but I'm talking litigators and what they do. And it's often a type A group and it's a tough group. And Dan, I'm really impressed you were able to shuttle this project through this year. I want to say some other amazing things about former Governor Bridges. You might notice our directory has been facelift. That's a direct result of a suggestion and recommendation of Dan Bridges that we need to honor our members and keep a record of their service to the Bar Association. And that's a change he made as a governor. Well, it came to fruition after he was a governor, but it's a change he started by his service on this Board of Governors. Dan and I haven't always agreed on everything, but Dan Bridges has always supported me and my values into leadership and has always had my back. I would not be president here today without his support, and we wouldn't have achieved much of our agenda this year without having the foundation he laid. Our budget and audit committee is the way it is, much due to the foundations he laid in writing what proper auditing should look like. So Dan, thank you for all that, and thank you for your work on this committee. We'll have resume business in 5 minutes, 11:12. Thank you, everyone. Thank you, Dan.
Thank you, Dan.
It's always been a pleasure and honor to serve all of you. Thanks, guys.